for not producing the primary evidence, after that explanation, you are allowed to produce the secondary evidence. You got the point? So the secondary evidence can be produced only if you satisfy the court about your failure with reasons and justified reasons and believable reasons for not able to produce the primary evidence. And there are so many occasions when in the courts we come across a situation where we are unable to produce the primary evidence. For example, if I have to prove some ancient scripture carved out on a stone, by no means can I produce that stone into the court. So that inability to produce the primary evidence, I'm allowed to produce the secondary evidence, but with the explanation that why I could not produce the original. You got the point? For example, if there is a bulk of record, which cannot be moved from one place to the other, but I have to prove those records before the court, and they are non-transportable, then I have to move an application to allow me to produce the secondary evidence. Sometimes during banking cases, we come across such situations that I have to prove certain transaction into the banking system or the bank accounts. Now the entire bank accounts cannot be transported from bank to the court because that will stop the banking work. So we have to produce a secondary evidence to that, satisfying the court why we could not produce the original. But the law says, where this primary evidence and secondary evidence is being defined, section 60 onwards, the first declaration is that the fact should be proved through primary evidence. This is the opening section. The fact should be proved through primary evidence. And 61 defines primary evidence, 62 defines secondary evidence. And then you have to move ahead. Then comes the real evidence and the personal evidence. Real evidence and personal evidence. The distinction between these two types of evidence is, real evidence is the evidence which does not have life. Non-living evidence is real evidence. Like I said, when you produce the weapon, when you produce the blood-stained clothes, these are real evidence. And what is personal evidence against real evidence? When the person with life, with human body comes in the witness box and gives evidence of the account of the act or incident, that is called personal evidence. So the second distinction is real versus personal evidence. Then there is substantive evidence and non-substantive evidence. There's another classification of evidence. Substantive evidence means important to the fact in issue. That is called substantive evidence. For example, if a killing has happened and the weapon is produced before the court, that is a substantive evidence that through this weapon this killing has happened. Against that, a non-substantive evidence is also an evidence, but non-substantive, which is produced before the court to corroborate the substantive evidence. For example, the cover of that weapon is produced. It is also vital, but it's not substantive, because the killing has not taken place due to the cover. But this corroborates the evidence that why the fingerprints are not on the weapon. Here was some kind of a rubber cover or something on the holder of the knife, and after the killing this cover was thrown the other side, the weapon was found from the other side. So substantive and non-substantive evidence. These are very vital facts which are to be produced in a trial, whether it is a criminal trial or a civil trial. Now the other aspect which is also being defined in the preliminary part of the Evidence Act is proved, disproved, and not proved. What is proved is when the court believes the existence of a fact or considers it probable in the estimate of a prudent man to have existed. Please understand once again. When the court believes the existence of a fact or considers it probable in the estimate of a prudent man to have existed, then the fact is said to be proved. So basically a fact is proved by court. If the court believes the existence of a fact, then it is proved. If the court believes that there is a probability of the existence of this fact, then it is proved. And just contrast to it, if the court does not believe in the existence of a fact or considers not probable to have existed this fact, then it is called to be disproved. And the third aspect is that when a fact is neither proved nor disproved, is called not proved. Neither proved nor disproved is called not proved. Now all this which I talked about just now before you is the subject matter of section 3. Section 4 says that the court may presume